Tyler Hamilton, Kirby Norman, Dustin Lightman, Jay Lee, J-A-E-L-E-I-G-H, William Nisley, Deanne, E-A-N-N-E Chambers, Roger Miller, Amber Michael, Daniel Whitney, W-I-N-D-N-A-G-E-L, alternate 1, Aubrey, A-U-B-R-E-Y Phillips, alternate 2, Helen Chrisman.
All right, back on record, State versus Duffield. Jury is in the jury room.
Aren't we all on YouTube?
Yes.
Even the conference?
Yeah. This is just it's on record. Okay. All right, there was a matter the state said it wished to bring up.
I just wanted to put on the record, Your Honor, the court ordered defense to return our plea offer rejection form to us, and Ms. Wells didn't advise me via email that she would on Friday. She didn't do that, and I asked for it today. She still isn't doing it. I just want to put on the record that her client is aware of what our plea offer was and that he is rejecting it.
All right, is that correct, Ms. Wells?
Yeah, it is. He is aware of it. I'm sorry.
Okay. You're aware of it, you've rejected it?
Yes, Your Honor.
All right, thank you.
Thank you.
All right. Okay, then let's bring the jury in. Be seated, please. All right, we're back on record. State of Ohio versus James Duffield. Now, ladies and gentlemen, before we begin the trial, I need to give you some additional instructions. Jury service may be strange to some of you, and so a short explanation is in order. Now, those who participate in a trial must do so in accordance with the established rules. That's true of witnesses, the lawyers, the judge, and the jurors. The lawyers present the evidence according to the rules. The judge enforces those rules and determines what evidence may be admitted. Now, and again, just to explain that, that's not what, I don't judge it based on what I think is fair or ought to be. I do it according to specific rules that I'm required to follow, just like you. Now, you will be the sole judges of the facts, credibility of the witnesses, and the weight to be given to their testimony. And at the end of the case, I'll instruct you regarding the law on that, and you'll apply that to the facts. It's your sworn duty to accept and follow the law that is given to you by the court. Now, the procedure for the trial will be as follows. First of all, the attorneys are going to outline what they expect the evidence will be. These are called opening statements. Opening statements are not evidence, they're not argument. They're simply a preview of the claims of each party, which are designed to help you follow the evidence as it is presented. Then the state will offer its evidence. After the state finishes their evidence, the defendant may, but is not required, to present evidence. If the defendant does present evidence, the state may, but is not required, to present what's called rebuttal evidence. At that point, the evidence will be complete. The court will then instruct you on the law regarding the charge. There will be closing arguments, and then the court will instruct on the verdict deliberations. And after that, the jury will return and deliberate. Now, procedure for questioning witnesses will be as follows. The party that calls a witness asks questions first. That's called the direct examination. I'll refer to it as direct or indirect, or cross, because cross is the questioning that is asked by the opposing party. Now, after that party is done asking questions, then the party that called the witness may ask additional questions only regarding those matters testified to on cross-examination, and that's called redirect. As indicated earlier, the jurors are not permitted to ask questions during a trial. Now, during a trial, it's likely attorneys will make an objection. This is a procedure by which an attorney raises a legal issue that's to be decided by the judge. I'll make that according to the rules that have been set down through the Supreme Court and the statutes enacted by the legislature. Now, if an attorney objects, then I decide whether the question and or the answer are proper. If I determine that they're both proper, then I'll say overruled. It means it'll be answered. If I say sustained, that means I've determined either the answer or the question are improper and cannot come into evidence. Now, occasionally, Witnesses will answer questions before the attorney can make an objection. And then, once I've heard the objection, if I decide that it was to be sustained, meaning it was proper and it should have been answered, then you'll be instructed at the end of the case, and perhaps during the trial, that you're to disregard that testimony, or that that testimony was stricken. So what that means is, we know you're not computers where you just erase it and it's gone. But what it means is that when the 12 of you deliberate in the jury room and somebody says, well, remember that witness says this, but that was something that was stricken, then you have to say to the juror who brings it up, no, we can't decide that, we'll use that because that matter was stricken. Now, it's important that you be fair and attentive through the trial, and again, this will be a relatively short trial, but during the progress of the trial and during the breaks, you're not to discuss the case in any way with anyone else. You are not permitted to allow anyone else to discuss it in your presence. And again, even among yourselves, you might ask, well, why is that? Well, during the lunch breaks, during recesses, you can't discuss it because you can only discuss it as a group of 12 jurors, as a jury. And so if 2 or 3 of you were talking about it and discussing it, that would be improper. You can only do that once it's been submitted to you, which means you have to have the law as well as the closing arguments and explanation as to deliberation before you can make that decision. And you must explain this rule to anybody you come in contact with during the break, like family, friends you may be talking with or meeting for lunch or something, and explain to them that you can't discuss it. Now, I've had the experience where people say, well, but I served on the jury and I was allowed to discuss it. Well, memories fade. They couldn't discuss it until after the case. Once they had returned the verdict, the case was concluded. But during the case, the law is nobody on the jury discusses the case with anyone or permits anyone to discuss it in their presence. Also, you're not to read anything on the internet about this matter. You're not to put anything on the internet. So I know a lot of people are involved in social media and may post what you're doing. I would request that you not post that you're on a jury right now because somebody might post, might know something about the case. You may not know anything about the case, but say, well, I hope it's, blah, 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 or this or that. And they may say something that you shouldn't have. And so just don't even mention it or post anything about this on any social media until after the case is concluded. As I indicated earlier, not to talk to the attorneys, witnesses, or parties during this matter, and they're not to talk with you. So, sometimes, people might, ignore you, and, if you say, excuse me, or good morning, or something like that, it's okay for them to respond, good morning, but, sometimes they won't. Don't take that personally. It's just because everybody's trying to obey the rules. You're not to investigate this matter in any way outside of the courtroom. So what does that mean? That means you can't do any research about the matter on your own. Don't look at anything on the internet about it or social media on your phone or anything else. Because as was talked about during voir dire, you have to decide the case only on the evidence that's admitted in the trial and the law that's given to you in the trial and nothing else. Now, being human, sometimes when we hear something, I know when I'm watching a TV program or maybe reading a book or talking to somebody, they'll say something. I say, well, let's look up what I can find out about that on the internet. Can't do that during the trial. Once the trial is complete, you may, but not during the trial. And as I indicated earlier, not to listen to any radio reports, read anything about it on the internet, podcast, or TV. I don't know that we'll make any of that. Again, like I said, the newspapers, we are live streaming now. The newspapers do follow it, and sometimes will write a story pretty quickly. Don't read anything on any of our news sites about this case during the trial. Now, if something should happen, and occasionally things do happen inadvertently, where something will happen that somebody says something to you, or you hear something, or something like that, report it to the bailiff. The bailiff will report it to me, and I'll confer with counsel, and then we'll address the matter. Now, sometimes that means I have to have you come in the courtroom and ask some questions of you. For that reason, don't, if you have any doubt about it, don't ask your fellow jurors what their opinion is. Is this something I ought to report? Because if you do, and you explain to them what happened, then we're going to have to question all 14 of you. And I had that happen about 25 years ago in a trial where it was like a 3-day trial and we had 15 jurors, we had 3 alternates. That happened, the juror came back and said to the others, hey, what should I do? Here's what happened, blah, blah, blah. We spent the afternoon questioning 15 jurors, so we lost a whole half a day trial. And, so it just makes things more complicated. And so if you have any doubt, err on the side of caution, report it to the bailiff. Now, as you've seen, from time to time, we'll have bench conferences. And when that happens, that's when attorneys are presenting a legal matter to the court, and I might ask for it, they might ask for it, and that's for us to discuss that. It also can involve something like logistics or things of that nature. But it's not to keep you from hearing something you should hear, because if you should hear it, you're going to hear it. And then sometimes when there's a legal issue that has to be decided, I might need to ask questions about what is the answer going to be and so forth. And so rather than doing that in your hearing, where then I tell you, nope, you can't consider any of that, that gives you more you're not to use, we take that burden off of you by making sure that you don't hear it. Note taking is not permitted on a trial of short duration like this. I don't permit notes because I think it sometimes distracts people from paying attention to the testimony and interferes with that. Okay. So with that, we're now going to hear the the opening statements. Opening statements, again, are not evidence. They're simply a preview of what the attorneys believe the evidence is going to be in the case, but they're for no other purpose than to assist you in understanding the evidence as it's presented. All right, on behalf of the state, Ms. Collins.
May it please the court, defense counsel, ladies and gentlemen of the jury, today the state will present the evidence necessary to prove beyond a reasonable doubt that this man, James Duffield, possessed an obscene picture of a child under the age of 18. Now, as the evidence and testimony start, it may sound like a complicated thing when you hear things like IP addresses, geolocations, things like that, but it's really just common sense. IP addresses are addresses related to an internet connection to a specific device at a particular physical location. Each one is unique, can be traced back to the computer or phone that owns it. In the summer of 22, ICAC, which is Internet Crimes Against Children, received a tip, what's called a cyber tip. And the tip was a specific IP address had downloaded a picture of child pornography. ICAC then did a subpoena to ascertain the owner of that IP address and that location. And the results came back that it was James Duffield living in Highland County. Well, based on that, they then forwarded the case to local law enforcement because it's here in Highland County. They sent the report to Detective Sergeant Erica Engle, who downloaded the image and contacted James Duffield in order to ask him about the picture. Detective Sergeant Vincent, or Vinnie Antonor, interviewed Duffield, and during that interview, Duffield admitted that he did in fact download these types of images.
Objection.
Overruled.
He admitted that he was attracted to younger girls, and that he would download these images of girls, masturbate to those images, and then delete those images. Detective Sergeant Antonor asked that Duffield call him if the urge to look at this became too much, and let him know so that he could get help for him. However, as soon as Duffield downloaded this one picture of a young female in a state of nudity, he possessed the picture, and as such, he is guilty of pandering obscenity involving a minor. And at the end of the state's evidence, I'm confident that you will find him guilty. Thank you.
All right, on behalf of the defense, Ms. Wells.
May it please the court. Ladies and gentlemen of the jury, she's right. This is a simple case because there's virtually no evidence of what Ms. Collins just stated. What the testimony is going to show is that there was an ICAC report. It did not state that Mr. Duffield was the individual responsible for whatever the tip was. That's just not true. Got referred to Detective Engle, who I don't know if she forgot about it, but it sat around for 8 or 9 months and nothing happened. Then it gets picked up, and Detective Antonor, I guess Detective Engle is the one who calls, James asked him to come in. Detective Antinor does the interview. Detective Antinor asks James a series of leading questions using something we call the read technique, which is designed to elicit incriminating responses. James stated repeatedly, over and over, "I do not look at child pornography." And he may not have used those exact words, but when confronted with the idea that he had downloaded an image of child pornography, he denied it. Now, the image in question was not presented to James. James never saw it. He, to this day, has never seen it. So there is no admission from James that he downloaded this image. There's no evidence in this case that he possessed this image. There is no forensic evidence. There's no scientific evidence. There is simply James was registered to an IP address. The IP address, contrary to what Ms. Collins just said, is directed to a home and all electronic devices associated with that home. There's one single IP address, and any electronic device within that home or that general area can log on to that IP address. There is zero evidence that whoever, if this was actually done in the first place, because no computers were seized, no search warrants were executed, no cell phones were viewed. Literally, no electronic devices were investigated by the police department. They didn't even ask James to turn his in. Again, it had been 9 to 10 months since the tip came in. I don't know, I guess we'll get to ask Detective Engle why no one executed a search warrant, as would be protocol in these cases. In any event, that's what you're left with. James stated, "I do look at adult pornography. I am interested in women that look young." He did not say, "I'm interested in young girls." He did state that at times, if he thought there was something that would be questionable, he would immediately delete it, and that was it. That's the evidence. That's the alleged proof. And based on that, we're going to ask that you return a not guilty verdict.
All right, thank you. First witness for the state.
Dr. Singh?
Which face is it? Stand for the case.
Were you sworn in the clerk's office? Were you sworn in downstairs at the clerk's office?
No.
All right, would you raise your right hand, please?
Yes.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Just have a seat over here. Let me ask you, Doctor, we are broadcasting this on YouTube. Do you care if your image is shown on YouTube or not? If you don't want it to go out on YouTube, I can block it.
Yeah, please.
Okay. All right, you may inquire. Oh, I'm sorry. Slide the microphone over there, Doctor. Toward your left, back toward the jury there. Opposite way, as far as it'll go. And please lean forward and speak into that so we'll pick it up. All right, you may inquire.
Thank you. Please state your name for the record.
Poonam Singh,
And can you spell your first and last name?
P as Peter, O, N as Nancy, A as Alpha, M as Mary, and last name is Singh.
And doctor, what is your current occupation?
I'm a pediatrician.
And where are you employed?
I'm working with Highland Health Providers.
Is that here in Highland County?
Yes.
And how long have you been employed there?
For last 5 years.
And what degrees do you hold?
I have a DCH from India and an MD from here. I did my pediatric training in El Paso, Texas.
And do you specialize in a certain type of medicine?
I'm a general pediatrician.
Okay, so pediatrician, so you see kids.
Yes, I see kids of all ages from birth till 18.
And how long have you done this?
This is my 30th year. I graduated my medical school at age 22, and then I did I came to US, but then I went back with my daughter and I did DCH for 2 years, which is Diploma in Child Health. I did pediatric ICU for a year, and then I did Senior Administrative Officer in India. And I came back and did pediatric residency in El Paso, Texas Tech Health Science Center. And after that, I came to Kentucky to work in Manchester Memorial Hospital. And then I did a couple of locums, and I went back to a permanent job, 2 different places. One was Turlock, California, and Owensboro, Kentucky, and then I came to Highland.
And the majority of that work experience has been with
Pediatrics.
pediatrics.
Yes.
At this time, I would ask the court to declare Dr. Singh an expert in pediatric medicine.
Objection?
No.
No.
And
No,
thank
Your
you.
Honor, thank you.
So declared, thank you.
Now, doctor, in your training, are there specific things that you're trained to look at on the body of a human to determine their age?
Yes, we do look at the sexual maturity rates for the boys and the girls. For the boys, we look at testes and scrotum, and for the girls, we look at the breast development and the amount of hair they have in their privates.
And have you specifically had training in identifying those things that would help determine the age range of a person?
Yes.
Have you worked with law enforcement in helping to determine the age of a child in pictures?
This is the first time.
May I approach?
You may.
I'm going to hand you what's previously been marked as State's Exhibit 1 for identification purposes. Do you recognize that?
Yes.
And how do you recognize that picture?
It's probably a pre-adolescent kid. The detective Vincent had come to me and he showed me this picture and requested me if I would testify to regarding the age.
Okay, so you've seen that picture before?
Yes.
Okay, and were you able to give Detective Vincent or Detective Antonor an opinion about the age of that person?
Yes, because the chest is very flat and there is no development of the breast tissue, so it is definitely less than 13 years of age.
And is that what you advised Detective Antonor?
Yeah, so because we had to write the legal age, so I wrote less than 18.
Okay. And is there anything other than the lack of development of breast tissue that you base that opinion on?
There's no hair at the privates,
Objection.
so
Can we approach?
whatever.
Okay, wait a minute,
the
doctor.
pubic
You may
band-
approach. Hold on a minute.
This testimony is outside the scope.
You were talking about hair on her privates.
Yes, I mean, I don't see any hair in the pubic triangle. Yeah. I mean, not in the picture, I don't see.
I have no further questions.
All right, cross.
Thank you, Your Honor. Dr. Singh, you're a pediatrician.
Yes,
Trained initially in India, then finished your master or your medical doctorate here.
yes,
Testified you worked as a locum in different locations. A locum is essentially a traveling doctor.
yeah,
And you've been in this area for six
this
years?
is the 6th year,
Okay.
since 2018.
Now, you had provided what's generally referred to as a CV or
Yes,
your background,
yes,
education and training and so forth. You don't have any training in electronics. You're not a computer expert.
no,
You're a pediatrician. You don't have any training in artificial intelligence.
no,
You've received no training in distinguishing real photos from those artificially generated by computers technology.
no,
Your first involvement, and probably only involvement in this case, came in August of this year when the detective came out to ask you to look at the photograph.
Yes.
You weren't involved in the grand jury preparation.
Here, I'm going to
No.
object.
Sustained.
You were asked to look at the photograph and prepare a statement regarding your observations.
Yes.
Your statement was prepared on August 21st. Remember that?
Yeah.
And said, I met Detective Vincent Antonor today.
Objection, he's testifying.
All right, ask a question. I'll sustain the objection.
May I approach?
Yes.
I'm going to show you a document. It appears to have your signature on it.
Yes.
Do you recognize that statement?
Yes.
In that statement, you said the subject has almost no breast tissue.
Yes.
May I retrieve the document?
Yes, you may.
Thank you. The photo that you were shown doesn't fully depict the vagina, does it?
No, it's not about the vagina, it's the skin at the privates, at the suprapubic area. There would be hair, really thick, coarse hair if it is an adult female, but it doesn't really show the vagina per se.
Right. You would have really thick hair, assuming that the subject, if it's a real subject, doesn't possess a razor, right?
Yes.
You were provided with no name of the, whatever appears to be in that photograph,
No.
no date of birth,
No.
no address that they live at,
No.
not even a state that they live in.
No.
Based on the photograph you were shown, you really have no way of knowing that that's a real person or a computer-generated image, do you?
No.
Thank you.
Redirect.
Thank you. A doctor, would knowing the name of this child change your opinion about her age?
No.
Would knowing the address of this child change your opinion about her age?
No.
Would knowing, may I approach?
You may.
Is there anything in that picture that changes your opinion about her age?
No.
So is it your opinion based on your training and experience that this is a child under 18?
Yes.
No further questions.
Thank you. You may step down. Next witness.
Detective Sergeant Vincent Antonor.
Were you sworn in the clerk's office?
I was, Your Honor.
All right. Do you have any objection being shown on YouTube? Or you care?
Prefer not to.
Okay, that'll be fine. Go ahead and have a seat.
Thank you, sir.
All right, pull the microphone over there in front of you, if you would, please. All right, you may quiet.
Please state your name for the record.
I am Detective Sergeant Vincent Antonor of the Highland County Sheriff's Office.
And can you spell your first and last name?
My first name is Vincent. Last name is Antonor, Antinore.
Have you watched any of this trial on YouTube this morning?
I have not.
And are you currently employed?
I am.
Where are you employed?
The Highland County Sheriff's Office.
How long have you been employed with the sheriff's office?
More than 10 years.
job duties there at the sheriff's office currently?
Currently, I am the supervisor of the Detectives Division.
What other positions have you held there at the sheriff's office?
I've worked in every division except our records office. So I started in our jail, then I worked dispatch and road patrol. I was just a detective for a while, and now I'm a sergeant in the Detectives Division.
For a time, were you assigned to a different office, so to speak?
Yes. So in 2018, when I first got promoted to the Detectives Division, I was assigned specifically to Children's Services here in Highland County to just work child cases.
Now, have you had, because of your work there, have you had specialized training in interviewing subjects?
I have, yes.
And what type of training have you had?
I'm sure it's pages and pages, specifically to interviewing interrogation. But obviously, the Basic Academy offers interview training that I took, and numerous web courses as far as, in-person training. I've been trained by the Reed Institute, which is based out of Chicago.
Now, it has been implied that the Reed training is specifically to get a suspect to falsely confess. Would you agree with that?
I would not, no.
Objection?
Okay, I didn't hear your objection. I'm going to sustain that objection. Just, jury will disregard that.
What is the purpose of the Reed training?
It's in conjunction with all of our other training. So the only thing we seek and that the Reed technique teaches is to seek the truth.
Now, were you so employed at the sheriff's office on April 25th of 23?
I was, yes.
And do you have a partner that you work with daily?
I do. That's Detective Sergeant Erica Engle.
And did you and Detective Sergeant Engle speak together about a case involving James Duffield?
Correct, we did.
And did your partner ask that you interview James Duffield as part of the investigation?
She did, yes.
And did you speak with James Duffield?
I did on April 25th.
Do you see James Duffield in the courtroom today?
I do.
Can you please put him out for the court?
So he'd be at the defense table with a blue shirt and looks like a dark blue tie, gray hair.
Please let the record reflect the witnesses identified the defendant.
So we're,
Now, Detective Vandenor, can you take us through that interview?
Absolutely. So the interview, obviously, as I stated, took place on April 25th of this year. Somewhere just before 3 o'clock in the afternoon, James came to the sheriff's office at the request of Sergeant Engle. I showed him to an interview room, began speaking with him. The interview itself was probably only maybe just a hair over 26 minutes long. So we started just, basic introductions. I explained to him who I was and small talk for just a moment. And then we kind of got right to the reason he was there, which was an image we had been investigating. So during the interview, James initially denied having knowledge of it. At some point during the interview, he did admit that, or he made the statement that the only images like that he'd seen was on a flash drive. Later in the interview, he confirmed that that's where he downloads his pornography to a flash drive. Stated that he erased it every single day. When I asked him specifically about child pornography or juvenile pornography, he stated that he had seen images of that before and even downloaded them and then got rid of them. James stated that initially he stated that he was attracted to young women. When I clarified exactly what he meant, he later stated that he was attracted to women 18 plus. When we dove into that a little bit deeper, James stated that he was attracted to girls that were 16 and older. When we dove into that a little bit deeper, James made the statement that he was attracted to all teens and up. Then when we dove into that a little bit deeper, I asked him if it would be fair to say that he was attracted to girls younger than 16. And he said that that would be fair, maybe a little younger than 16.
Did you ask him what the purpose of downloading these images were specifically?
I did.
And what did he tell you?
He explained some sexual frustrations he has at home, and that he masturbates while looking at the images he downloads onto his flash drive.
Were you concerned with the statements that he gave you?
Absolutely, I would.
Did you ask him to follow up with you about anything?
I believe I did, yes.
What did you specifically ask him to do?
So I told James that there's a difference between looking at images and actually seeking out young women. I asked him if he ever got to a point during his sexual exploration that if he found himself seeking out a young girl, that he would call me immediately.
Now, during your questioning of Mr. Duffield, did he indicate that anyone else downloaded these types of images?
He did not, no.
During your questioning, did he claim that he possessed them for any purpose like medical, scientific, educational, religious, governmental, judicial, anything like that?
No, he did not.
Why did he possess them?
According to what he told me, it was for the purposes of masturbation.
I have no further questions.
Cross.
Okay, Ellen.
What's that?
Can I have that copy too? Detective Ansnor, I'm Lisa Wells. I represent James Duffield. It's nice to meet you.
Absolutely, thank you.
Detective Duffield, I'm sorry, not Detective Duffield, Detective Ansnor. This tip came to your sergeant, correct? Originally, Engle?
Yes, it came to Sergeant Engle.
Okay, and then how many months went by where it sat there and you did nothing?
No, I don't know.
Would it refresh your recollection to look at a report?
It would not. I don't know when the original report came in.
No, would it refresh your recollection to look at your report?
It might. I don't know that I authored a narrative in this report.
Isn't it true that you didn't write a report in this case?
Yeah, that would be correct.
Okay. And you are the lead detective on this case, correct?
No.
I'm sorry, it's Sergeant Engle's the lead detective on this case?
Correct. I only done the interview in this case.
You did the interview in this case. Okay, so you talked about your training, correct?
Yes.
And I've reviewed your personnel file. You've gone through a lot of training, right?
Okay. But I'd say that's fair to say.
And a lot of your training has to do with how to write reports, correct?
How to what?
Write reports.
I wouldn't agree with that statement.
Okay, how would you characterize some of your training in regards to writing reports?
Well, I would agree that some of the training is regarding writing reports, but certainly not a lot of it.
You would agree with me that some of the training regarding writing reports is because you should do them. You should write reports, correct?
Well, I agree that reports should be written, yes.
Right. I'm sorry, are you saying that as an investigator of a felony offense, you shouldn't have to write a report?
I believe that you should, yes, and I believe there's a report done in this case.
By you?
No, I did not author any reports in this case.
Right, I think you're not hearing my question. Are you stating that if you are investigating a case, regardless of whether you're the lead detective or not, is it consistent or inconsistent with your training that you personally should write a report?
So I think what you're asking or trying to ask is why I didn't author a narrative regarding the interview?
It's not. Do you want me to
Okay.
repeat my question?
Sure, because I don't quite understand it.
Okay. You would agree with me that in your training, they talk about writing reports, correct?
Yes.
And the reason they talk about writing reports is because it's important to write a report, correct?
I would agree that writing reports in law enforcement is very important.
And that applies to not just the detective on the case, but any law enforcement individual that has anything to do with the case.
I
Right.
would not necessarily agree with that statement.
Okay, why wouldn't you agree with that statement?
Well, like in this scenario, when you do an interview that's audio and video recorded, the interview kind of speaks for itself. So if Sergeant Engle were to do a narrative that I completed an interview and put in that narrative that you should see the interview for context, I believe that's a lot more powerful than what I could write down about what I remember about the interview.
Right, so your personal recollection is not dependent upon a report. Is that accurate?
I don't think that's what I stated at all.
Okay, well, I'll ask it. So how is your memory from April 25th of this year?
I'd say I don't remember what I had for breakfast, but I mean, if you're asking about the interview, I'd have knowledge of the interview and believe that my recollection regarding the interview is pretty sufficient.
Okay. So, have you reviewed the recorded interview?
Several times, yes.
When was the last time?
Today,
When?
sometime this morning,
Okay. When was the last time you watched it before then?
probably Thursday or Friday.
And before that?
I don't recall.
So you should be very familiar with what was actually said in the interview, correct?
I would agree with that, yes.
And you're telling this jury that what you just testified to when Ms. Collins asked you questions matches with the video. Is that what you're saying?
Yes, everything that I testified to, answers as far as Ms. Collins' questions were accurate in the audio and video.
Okay, so. You stated that at first, Mr. Duffield admitted to being attracted to women that were 18 years and above.
Correct.
Is that true? When during the interview did that happen?
Probably sometime between the, I don't know, maybe 14 and 17-minute mark.
Do you think if you saw a transcript of it, you would be able to identify it?
There was no transcript done on this interview. We don't routinely do that.
If I had a transcription of it, do you think you would be able to identify when that statement was said?
If there were a transcript done regarding this interview, it's possible. As far as if you had a transcript done, I'm not sure who done it or the quality of the transcript, or I'm not sure that it would be accurate.
Okay.
Typically, if we're going to have a transcript done, it wouldn't go this way.
Okay, so if it is transcribed by a court reporter that has a certificate that's authorized to do transcriptions in the state of Ohio, would you then agree with me that it's probably reliable?
I would not agree to any statement that involves the word probably. And I certainly wouldn't agree that some court reporter that I don't know, nor do I know where she received her certificate or how she viewed this interview or what audio quality she listened to it on, would be even remotely accurate. I usually try to be a little more detailed and in-depth when it comes
Okay.
to things like this.
If you watched the video, do you think you would be able to identify when my client said that he was originally attracted to women 18 and up?
It's certainly on the audio and video recording, yes.
Is it? Judge, I'm going to ask for us to take a break at this time so that we can play that video.
You don't have it ready yet?
No, Judge, I've planned on using the transcript. I didn't foresee a problem with cross-examining
All
him
right.
as to court reporting.
Ladies and gentlemen, if you would retire to the jury room and we'll get the equipment to do this. Thank you.
Where's the TV?
Hold on, I just want to, I don't know what we're going to need in terms of equipment here. All right. So, the defense has the tape or the digital recording on a laptop. The question was whether or not, if he looked at the video, he could determine at what point in the interview the statement that he said the defendant made can be found. So the court's ruling is that he can look at the video to define that, and then after he's reviewed it for that purpose, then we'll come back on the record with the jury. Now, if you anticipate asking other questions, then I would suggest that you make those points and ask him to look at that, so that when we come back, then you can ask those questions as to whether or not they were on the video or not. All right, now, anything further?
So he made somewhere around 7 or 8 statements about what was said by my client that wasn't said by my client during this interview. So I would like to ask those questions in front of the jury and then him answer.
Questions about what? The purpose of the video is for impeachment or to refresh his recollection.
It's impeachment. Our client didn't say anything regarding being attracted to kids that were then 16 or older.
Well, you're going to have to let him look at the video. I mean, you say he didn't. He said he did. Now, it's not on there. It's not on there. So, if you want to, you ask him at what point, and I understand he said 14 to 17 minute mark approximately. So what I'd suggest you do is tee it up about that point, maybe a little earlier, maybe a little, and let it go until he finds it. If he doesn't, play the whole thing, and then he can answer the question. And if it's not on there, then you can ask him. You just listen to the whole video, and you didn't hear that, and he'll answer the question.
I guess just while we're creating a record, Judge, Rule 1002, requirement of originals, suggests that testimony regarding statements made during the video or any recorded statement, the original recording is the best evidence. And I think that's what Ms. Wells is trying to get at.
Okay, well,
And playing the entire video.
It is a piece of evidence, but it's not necessary. And the court's practice is that the portions that are admissions against interest under the rules of evidence can be admitted, but those portions that are not admissions cannot be admitted because they're not admissions against interest. So that's why I don't encourage or usually permit upon objection playing the entire video. All right, so I'll take a break while you do that.
Your Honor, do you want the large screen or do you want him to do it on the laptop?
They're just going to do it on the laptop because it's not evidence for All right, we're back after the intermission. All right, what's the situation?
Judge, your local rules provide that a transcript can be used as long as it's by a person certified by Ohio, which this is. We should be able to cross-examine
I haven't ruled
from
that you can't.
the transcript.
Yeah, I haven't ruled that you can.
We would like to. Is that okay?
Yeah, for whatever it's worth.
Okay. Then, Ms. Collins.
Now, you asked about, we took a break so you could show him the video, so
He
I
watched.
expect questions to be asked about that.
Right, so you watched the video.
All right,
Right.
all right. So when we resume, that's why we broke. We didn't break for, for the
Yep, that was all.
testimony. Pardon me?
No, that was all.
All right. Bring the jury back in. Yeah, close that window because it's kind of noisy. We're cool enough, I think.
Child pornography.
Be seated, please. All right, we took a break so that there could be some matters considered. So we're still on cross, so Ms. Wells, you may continue.
So you've had an opportunity to review the video now, correct?
I've reviewed some of the video, yes, not the video in its entirety.
Right, and you were able to identify a place where he said that he was interested in young women?
Correct, yes.
Right, and then according to it, you said that he was interested in women that could appear younger than 18?
Well, I don't think that's what I testified to.
Okay, what did you testify to? I'm sorry, taking the break.
At different points in the interview, James stated at one point that he was attracted to young women 18 and up. At another point, he stated that he was attracted to teens and up. At one point, he stated he was attracted to 16 and up. At another point, he said that maybe younger than 16.
Okay, is it illegal to be attracted to younger looking women?
Not that I'm aware of.
Okay. All right. And so when you say he said these things, correct me if I'm wrong, but you're actually stating it. Like you're stating, isn't it true? Well, I'll just give it to you. It's very clear from your search history that that is correct. When did you go through his search history?
What do you mean?
Okay, we'll start over. In your questioning of James, you made reference to this deep investigation that you did in this case.
Yes, I believe so.
Okay. But you didn't actually do a deep investigation into this case, did you?
No,
No. So you lied.
absolutely I did, yes.
And you misrepresented what kind of evidence you had.
I think that means that I lied to him, yes.
Right. And I think we talked about the Reed technique, and I didn't characterize the Reed technique as trying to get false confessions. But you would agree with me that the Reed technique that you've been trained on is designed to get individuals to open up and talk to you, correct?
Yes, I think that's a correct statement. It's designed to elicit conversation, truthful, honest conversation.
Right. And you use a number of tactics like acting sympathetic to James's situation. Is that accurate?
Are you asking, did I use that technique in this specific interview?
Yes.
Yeah, I believe so, yeah.
Okay. And basically saying that he's not really a bad guy. Didn't you use that technique?
I'm sure I said something substantially similar to that, yes.
Okay. And part of your Reed technique training is to minimize the culpability of the individual that you were interviewing, correct?
Absolutely it is. So we wouldn't use words like rape or murder or any words that trigger a negative response.
Okay. So when you started interviewing James, you talked about the fact that you had done an investigation into his search history. right?
Probably so, yes.
Right. But neither you nor any law enforcement member have ever done any investigation forensically into any computer, correct?
Correct, that is correct, yes.
Or into any cell phone, correct?
That is also correct, yes.
Or into any electronic device that could have been related to this IP address. Is that correct?
Yes, I mean, I think I answered this question with your initial question. We did 0 search warrants on any type of computer or cell phone or anything like that.
Why not?
We had the image of child pornography. When I talked with James, he states that he deletes this type of pornography all the time.
If I
mean,
could
are
step-
Your
you?
Honor, he's not finished answering.
Yeah, let him finish
I'm
his
sorry,
answer.
go
No,
ahead.
wait, let him finish his answer. Continue
I
your
said
answer.
I don't know if you're suggesting that there's more child pornography on these devices we should have looked at, but we had the image of child pornography that he downloaded because it was captured electronically. When I talked with James, he admitted his attraction to young women. He admitted that he downloads these images and then deleted them. This specific image, he didn't deny downloading, he just said he couldn't recall it specifically. And of course, I wasn't going to show it to him to see if he would recall it specifically. And I didn't necessarily see a need to search his cell phone after that. We were only investigating the one image.
Okay, so let's go back to that. So when you say that Mr. Duffield admitted to downloading an image of child pornography, where in the interview does he say that?
I believe we were talking about child pornography, and I believe what he said is that he downloaded or that he viewed some on his flash drive that were young girls, but that he got rid of them.
Okay, so correct me if I'm wrong, but that statement is entirely different from the statement you said before, right?
I don't agree with that statement.
You said that James said that he downloads child pornography to a flash drive and then he deletes it. You said that James said that. Is that
Well,
right?
I characterize it as child pornography because it's somebody under 18. James characterized it as young girls.
You defined child pornography for James during the interview?
I did not. I'm defining that now.
Okay,
That when I say child pornography, those aren't necessarily James's words. It's how I refer to pornography of somebody under the age of 18.
Okay, but James never admitted to downloading any child pornography, correct?
I believe what James said during the interview, which again we have a recording of, is that he had images, that he downloads his pornography onto a flash drive.
Yes.
And in the beginning of the interview, he said that the only time he's seen images are on a flash drive. And later in the interview, he said that he did have some of, I believe he said something substantially similar to young girls, but got rid of them.
But none of that is, I download child pornography to a flash drive, right?
Well, he certainly didn't use those words exactly, just like in the interview, I don't use words like murder and child pornography. I didn't use those words in the interview either.
Okay, and you never showed him the picture, correct?
That is absolutely correct.
Right, so he couldn't deny ever downloading that picture because you never showed him a picture, correct?
I would
It's
not.
yes or no?
Ever, no, I did not show him child pornography.
Okay, you didn't show him the evidence in this case, correct?
The evidence was child pornography, and I did not show that to him.
Right, and you didn't give him the ability to deny downloading it, correct?
I would not show him child pornography.
Okay, I'm going to ask you a series of yes or no questions. If you could answer yes or no, I would really appreciate it.
I will do
Okay?
my best.
Did Mr. Duffield admit to possessing child pornography? Yes or no?
I cannot answer that question, yes or no.
Did Mr. Duffield admit to possessing the picture that's in evidence in this case?
He did not. He stated that he couldn't recall that specific image.
You never showed him the image, so how could he deny recalling that image?
I don't know how he denied recalling it, but he did.
Where in the interview does he deny possessing the image that's in evidence in this case? case.
Exactly. He does not deny possessing this image. He states that he cannot recall this image.
If you don't show it to him, he can't deny possessing it, right?
I would not agree with that statement.
How is he going to admit that he possessed something that he doesn't know what it is?
Well, he either knows that he downloads child pornography or knows he does not.
I'm not talking about child pornography. I'm talking about this case, this one count, this one picture. He never admitted to possessing this picture, yes or no?
Correct. He did not admit specifically to this image.
Did he admit to downloading this image?
I just answered that. He stated he could not recall this specific image.
Could he recall other child pornography images that he downloaded?
Yes.
He could? Where in the interview did he describe child pornography images that he downloaded?
What he said, and I believe I stated this just a moment ago, is that he had pictures of some young girls and got rid of them.
Okay, when you say you have pictures of young girls, do you understand that pictures of young girls is not the same thing in every case as child pornography? Do you understand there's a difference between that?
Well, in the context of this interview, we were focused on child pornography. That's specifically what we were discussing.
Okay, so to answer my question, he never admitted to downloading images of child pornography, correct?
I would not agree with that statement.
Okay, because you say that he said young women. Did you ask him if they were young women engaged in sexual activity?
I did not.
So Mr. Duffield did not admit to downloading, possessing, or ever viewing images of young girls engaged in sexual activity.
Your Honor, objection. He's not charged with that.
Once you state that, you can have to rephrase.
He's indicted for downloading and possessing child pornography.
Well, actually, that's not the language of the statute.
Obscenity.
You need to use the language of the statute, and child pornography is not in it.
You didn't testify at grand jury, did you?
I don't recall. I testified at a lot of grand juries.
Do you think if you took notes, you'd be able to remember something like that?
If I took notes about what?
When you testify and when you don't?
I do not take notes when I testify and when I don't.
Okay. So have you seen a copy of the indictment in this case?
I have not.
Okay, can I approach?
What are you asking?
Asking if he's seen a copy of the indictment in this case.
Okay.
Okay, you're familiar with the indictment now?
I mean, I have a copy of it in my hand, I believe, yes.
Let you keep it. Okay. This specifically talks about on or about June 2nd, 2022. Did you ask James any questions about June 2nd, 2022?
I did not.
Do you have any evidence that he downloaded an image on June 2nd, 2022 that was obscene material?
I believe we have the image.
I understand that you have an image that you believe to be obscene. My question is, do you have any proof or evidence that that happened on June 2nd, 2022?
Well, as the indictment states, it was on or about June 2nd, so it's reasonably certain that it's around that date. And when I talked to James initially during the interview, when I asked him if he downloaded child pornography, one of his first questions was, when? And I said, well, approximately a year and a half ago.
Judge, if I could stop, because I have numerous questions that he's going back to that then I can't get back to because he keeps talking.
Well, you have to let him finish his answer when you ask a question.
He's not moved to strike non-responsive. He's not actually answering any question.
All right, I'm gonna stop it there. Let's move on.
Okay, I believe you said that when you brought him in, you asked him about child pornography and he said when? Was that your testimony?
Something substantially similar to that, yes.
Okay. Do you know in the video when that happened?
It's Right, pretty close to the beginning, I believe. I don't know exactly, but I would say it's pretty close to the beginning.
And did you use the word child pornography?
Of course, I did not use the words child pornography. As I've testified previously, we don't use words that elicit negative responses like child pornography or rape or murder during interviews. That's consistent with my training.
So, correct me if I'm wrong, but during the interview process, at the beginning of the interview process, you asked questions about Time Warner, correct?
I believe so, yes.
Okay. And you asked him information about his router.
I think he gave me some information about his router as far as he set it up with his personal information.
And then you ask him about, you tell him he's not under arrest, but you're trying to determine if something popped up accidentally and he looked at it. Would that be accurate?
That's probably something very substantially similar to that, yes.
And isn't his response, mm-hmm?
I don't recall.
If I showed you a transcript, would you have a reason to disagree with the transcript?
Possibly, yes.
Would you like to watch the recording?
If you think it would help.
You testified that when you brought this up, he said when.
Yeah, I think so. If you're looking for it, maybe on the recording or in your transcript, I think it was probably shortly after I said, let's not beat around the bush or something of that nature.
Can I approach the witness?
You may.
Can you take a look at that page for me?
Sure.
You state, yeah, well, and I think that's kind of the basis of we can beat around the bush for the next hour if you want to, but there's really, I don't want to waste any of your time, you know what I mean, but kind of, the basis of what we're getting at here is some stuff you were looking on the internet.
What line are you on?
They're not marked.
They are?
13.
13, okay.
Are you there?
Yep, I gotcha.
Okay. And keep in mind you're not under arrest. But what we're trying to determine, is this something that like popped up accidentally and you looked at it? Or is this something that you're searching for, if that makes sense, right? That's your question, right? What's his answer?
According to this, his answer was, mm-hmm.
And then your next statement was, so I think you have an idea what I'm talking about, right? And neither one of those answers are when. Isn't that correct?
Those answers are not when.
I'm sorry, the answers in this transcript are not right?
No, I said they're not when. You asked, are they when?
Yes, you stated a few minutes ago that when you brought him in and you asked him a question, that you started talking about this in general, that he said, when? I have just read you your first two questions, and his responses are not when. Isn't that accurate?
Well, I didn't say that it was
It's
within
yes
the...
or no.
Can you repeat the question?
Are James's answers to your first and second question on page 3 of this transcript in relation to a question you say you asked about generally why he's here for, and you say he said when? Did he say when in response to either one of these questions?
I did
Yes
not.
or no?
Your Honor, I cannot answer that question. What's happening is she's saying I said something that I did not.
Answer the best you can.
Perfect. So I never testified that he said that within the first two questions that I asked. I said that it was in somewhere around the beginning of the interview, I believe. I would agree that during those first two questions, he did not state when.
Please show me in the beginning of the interview when he said when.
I've identified it on page 14.
Okay, by the time we get to page 14, I think you have asked somewhere between 27 and 30 questions. Do you think that's the beginning of the interview?
The interview was 26 minutes long. I would characterize this statement in the beginning of the interview, yes.
Okay. But you would agree with me that the assumption you're trying to make, that when you asked about porn and when he did something, he said when, would not be accurate.
According to your transcript, he says, "How long do you suppose it's been?"
Where does it say that?
Page 14, line 14.
How long? Yeah, okay, so that's in response to you stating, I don't get the sense that you're a bad person. Please don't give me that sense now. And James says, I'm not trying to, honest. So then you say, so I'm just going to ask you man to man, 100%, you understand what I'm talking about. There was at least an image that depicted a juvenile that you saved from the internet. He says, well, how long do you suppose it's been? Correct?
Correct.
Right. And you say, back last year, last summer. That's what he says, correct?
That's what I said, is back last year, maybe
Right.
last summer.
Because he's asking, well, when do you think this happened, correct? And then you answer, back last year, last summer.
Yes, so I asked him to be 100% honest. There's at least an image that depicted a juvenile that you saved from the internet. And his response was not no. He said, how long do you suppose it's been?
Isn't it true that for the 10 or 11 pages before that, he said no to your answers?
I think according to your transcript, a lot of the stuff he said was,
Okay, would you agree that he didn't adopt it and say, yes, that's right?
Did he say that's right to what question?
To looking at child pornography or obscene material or images involving
Counsel,
a young woman.
let's stop using the word child pornography. That's not the law. The law is obscene material, and that's what's in the indictment. So let's concentrate. If you're going to ask a question, represent the law correctly.
He didn't say that in the first 10, 11, or 12 pages of this interview, correct?
He didn't say what?
That he possessed obscene material.
He did not.
And he didn't say that he downloaded obscene material.
Not in the first 11 pages of this transcript, he did not. Later in the transcript, he makes similar statements.
He makes a statement later in the transcript that he downloaded obscene material?
I believe he says something substantially similar to that he had images of young girls and then he got rid of them.
Okay, are images of young girls and obscene material the same thing?
We were talking about obscene material at the time. I would infer, as I think most people would, that that's what he was referring to.
I'm sorry, so you're inferring what you think he thought?
It was in response to a question about obscene material.
I'm sorry, did you use the words obscene material?
I did not. I'm using them now because
So it wasn't in response to a question about obscene material?
not the words obscene material.
Right, okay. Did Mr. Duffield identify other individuals that had access to electronic devices that were connected to his IP address?
Not exactly. What Mr. Duffield stated, and you'll see it here on page 14, is when I told him that this happened last summer, he said that at that time his brother and someone else did have access to a computer, but he got rid of them, kicked them out or
Okay,
something.
so during this time frame that you say that this happened, that someone possessed or downloaded an image of obscene material, there were other people living at the residence, is that correct?
There were several other people living at the residence, yes.
Did you investigate those other people to determine whether or not they could be responsible for either possessing or downloading an image of obscene material?
There was no need to do that.
He identifies his brother and his friend, correct?
Well, he doesn't identify him. I mean, he states his brother. He never provided any names or anything.
I'm sorry, did he use the words, "It was my brother and his friend"?
Probably something similar to that, yes.
Bottom of page 14, please.
That's what's here on this page, yes.
Okay. Then you state, yeah, but I know I can prove what device it was. Is that
Probably.
accurate? Could you prove what device, where someone possessed obscene material or downloaded obscene material? What device was it?
In this case,
Yes.
as I stated before, I lied to James several times during this interview.
Right, you were trying to convince him that you actually had evidence that you don't have, right?
That's a rough way of putting it, yes.
Right, and you don't have that evidence now either, do you?
As far as what device or computer?
Yes.
Correct, we do not have a computer or a device.
And that's because you didn't execute a search warrant for it, correct?
There, in my opinion, based on my training and experience, there was no need to execute a search warrant in this case.
Have you been trained with ICAC or NCMEC?
Specifically with them?
Yes.
No, I have not.
Have you worked on any task force with ICAC or NCMEC?
I have not, no.
Okay. Have you been involved in any cases involving internet crimes against children or the National Center for Missing and Exploited Children?
Several.
So, in those cases, were search warrants executed?
I don't know what they do routinely as part of their investigatory work.
That wasn't my question. My question was, in the cases you've been involved in, were search warrants executed?
I don't know. Like,
Your Honor.
you mean specifically at our office?
No, I asked you if you would answer the questions. What I asked was, have you been involved in investigations with ICAC and NCMEC? And you said yes.
Correct.
I asked, in your involvement in those cases, are you aware whether or not search warrants were executed in those cases that you were involved in?
So ICAC, or as we refer to it as ICAC,
Then move to strike. He either was involved or he was not involved.
Answer the question, yes or no.
can you restate the question, please?
And I believe I restated it wrong the first way. You were involved, you've stated you were involved. Were search warrants executed in those cases or not executed in those cases?
Not all of them.
Were some of them search warrants were executed?
In some cases, yes, we execute search warrants.
And after the search warrant is executed, do the electronic devices go to BCI?
In some cases, yes.
And BCI has the ability to forensically evaluate whether or not any child pornography or obscene material or anything that violates the law is on those computer, cell phone.
Your Honor, I'm
correct?
going to object for several reasons. A, it's not relevant because it didn't happen in this case. And B, Detective Antonor can't possibly be asked to testify to what BCI can do.
All right. I would agree with that. I'll sustain the objection.
Thank you.
Have you ever, in any of your other investigations, sent a computer or electronic device out for forensic search?
Yes.
Okay. And from a forensic search, you can get data about what time something was downloaded, correct?
Sometimes.
Okay. You can get information about email accounts, correct?
Sometimes.
You can get information about images that were saved,
Sometimes, yes.
correct? Okay. And in those cases, was that evidence that you used in the crime, or was that evidence of the crime?
In past investigations, some information that we gained from search warrants on electronic devices has been useful in, or has had evidentiary value.
Right, and sometimes it forms the basis of a count, correct?
Sometimes, yes.
Right, and that would be proof that whoever possessed that possessed the image, correct?
I think in this hypothetical scenario, yes, that could be proof that somebody possessed an image if they had a device that had it on there.
And you don't have any of that in this case, correct?
Proof that James possessed the image or a device? Because I've already said we do not have a device.
Do you have proof that James possessed any electronic device that had any obscene material on it?
I believe according to James's own statements, he used the words young girls, and of course I didn't use the words obscene material.
I'm going to ask it again.
Okay?
Do you have any electronic devices that have been searched that showed that James possessed obscene material?
No.
Do you have any electronic devices that shows that James downloaded obscene material?
As I've stated several times
It's
already.
yes or no.
We did not search, collect, or have any computer, cell phone, or any kind of electronic device.
So the answer to that question is no, you don't.
I just answered that question.
Okay, so despite James Duffield identifying other individuals that had access to that IP address, and you didn't investigate those, correct?
There was no need to.
He talks about what kind of pornography he likes to look at, correct?
Correct.
And does he identify cosplay porn as something he likes to look at?
Yes, he does.
Is cosplay porn illegal?
I have no idea what cosplay porn is.
Did you look it up?
I did not.
You didn't think it was relevant to know what kind of, if you're charging someone with obscene material, you don't think what kind of porn they're like is relevant?
No. I have no interest in what kind of porn anybody likes.
You were interested in what type of obscene material Mr. Duffield looks at, correct?
Correct.
You weren't interested in investigating whether or not the type of pornography or the type of obscene material he was interested in would line up with obscene material?
At no point in my training and experience in child crimes, child pornography crimes, interview and interrogation, has any type of obscene material, child pornography, or juvenile images ever been described as cosplay. It was a word not familiar to me, and I'm sorry, but I was a little afraid to type it into my web browser.
You were afraid to type something into your web browser. Isn't it your duty to investigate statements made by a suspect?
It is my duty to seek the truth while investigating crime.
You don't think seeking the truth is looking into statements made by the suspect?
I don't think it's looking up cosplay pornography.
Okay. Okay. You have stated repeatedly that James said that he downloads stuff to a flash drive and then erases it.
Correct,
Yes.
that's what he told me.
Do you have the flash drive, or have you ever had the flash drive?
We do not, nor have we ever had that flash drive.
Did you ask James for it?
We did not ask James for that flash drive.
Did you ask James for consent to look at his electronic devices?
We did not search any phone, computer, or any type of electronic device.
And when you say that he admitted to saving a couple of images back in June, you described those as juvenile images, correct?
I never said that he admitted to saving the images back in June. What James told me during the interview is that he had images of young girls and that he got rid of them.
Okay. You don't arrest James after this interview, correct?
That is correct. He was not arrested after the interview.
And after he was arrested, did you do any additional work on this case?
I did not. My sole involvement in this case was the interview portion.
Right. Except at some point you got in contact with someone from the prosecutor's office
I talked to them on a regular basis, probably daily.
about this case?
Not about this case specifically, but I talked to them regularly.
How do you know the expert that just, or you weren't in here, I apologize. So Dr. Panam Singh testified previously. How do you know her?
I do not know her personally.
Okay. Did you select her to be the expert in this case?
I did not.
Do you know who selected her to be the expert in this case?
I have no idea.
Okay, well then why did you go how did you know to go interview her?
I went to talk to her because she's a pediatrician that specializes in children.
I understand that. But did you decide to pick her, or did someone else decide to pick her to talk to?
I decided to go talk to her because she's a local doctor.
Okay, so you selected Dr. Singh as the expert, correct?
I cannot select someone as an expert to testify in this court. I chose to go talk to Dr. Singh, who is a pediatrician here locally in our county.
And that was after Mr. Duffield had been indicted, correct?
That is my understanding, yes.
Okay. And was that as a result of someone asking you to do that?
No one asked me to go talk to Dr. Singh.
I understand that no one asked you to talk to Dr. Singh. Did someone ask you to obtain an opinion as to the age of the child?
Probably something similar to that. I think the question was, do we have somebody that's going to testify that this is a child?
Right, because when this case was indicted and charged, you didn't have any of that evidence, did you?
You're not going to object. What the grand jury saw is not
I'm
relevant
gonna
to this.
sustain that, any reference to the grand jury.
Okay. Okay, under the law, you agree that this has to be a real child, correct?
I would agree that the law says a child, yes.
A real child, is that accurate?
I don't know that the law uses the word real.
Okay, do you have any evidence that the picture in question here, that is an actual child, a real live child?
I believe there's a picture of her.
Are you familiar with AI images?
I mean, I'm familiar with the technology specifically.
And are you aware that you can create an image that looks like a young girl but is not in fact a young girl?
Are you saying that you can AI generate child pornography?
No, you can request AI to generate it.
Okay. I wasn't necessarily aware of that.
You've had no training in AI?
Correct.
Okay, and you've had no training in regards to obscene material?
I've had a lot of training in regards to obscene
And
material.
in regards to your training of obscene material, when it comes to identifying the victim as a person, what training did you receive?
I don't understand the question.
In your trainings, did you receive information on how to identify when you see a picture of someone, whether or not they're a real person? Have you received training like that?
I wouldn't know. I don't think specifically to the answer to your question. I mean, we always use common sense. When we see a picture of a naked child, we assume that it's a naked child.
You agree, though, it's proof beyond a reasonable doubt. It's not just your assumption, right?
Correct. That's why Dr. Singh was here.
That it's a juvenile, correct? That her testimony was that it was a juvenile, not it was a real child, correct?
I wasn't in here for her testimony, nor did I watch it.
Okay. Are you familiar with any of the law enforcement search availability options for taking pictures like this and verifying whether or not they are in fact a real child?
I am not, no.
And none of your training has talked about like CFIP or using NCMEC?
No. Like to upload the image to or something?
To take the image and compare it to gigantic databases that have millions of images in it of identified children that are real children that have been identified.
Well, I think there's a big difference in that and what you asked me. Whether she has been identified or not does not mean she's not a real little girl that needs our help.
I didn't say that. What I said is, did you...
You said identified, and I don't know that she has or hasn't been identified, but that shouldn't decide whether she's real or not.
I think we're going to let the jury decide what's real or not.
I would hope so.
However, there are resources available to you with law enforcement that you could have run that picture through to determine whether or not that child has been determined a live child, correct?
Not that I am aware of.
Okay.
In my training and experience.
I moved to strike. I didn't ask a question.
Okay.
Have you seen Sergeant Engle's report?
Have I reviewed it? No.
Have you ever, I'm sorry, reviewed or seen, have you ever looked at it?
I've physically seen it, yes. I don't know that I have ever read it in its entirety, nor could I quote it to you today.
Did you provide information to Detective Engle that she used in the report?
I don't know what she put in her report.
Can I approach?
Okay.
Does that look familiar? She gave him Yes, does that look familiar?
I was reading it. It looks familiar in the fact that it looks like how our reports would be printed. Until now, I have not reviewed this report or statement, so I wouldn't say the wording of this is familiar to me.
Okay, I'm sorry, just, have you seen this paper before?
Not this specific paper, this format, yes.
I understand you've seen the format because it's your agency format, but have you seen the paper that had this information on it before today?
No.
Okay. Did you provide the information to Sergeant Engle that James stated that the pornography he downloads often contains that of juveniles in various states of nudity? Did you provide that information to Engle?
According to what you've handed me, it doesn't say that I provided her anything like that.
I'm not saying it's according to this. I'm asking you if you provided her with the information that James stated the pornography he downloads often does contain that of juveniles in various states of nudity.
Did I tell her that?
Yes.
Not that I recall, no.
Just a moment. And to your knowledge, you're the only person who's ever interviewed James, correct?
In regards to this case,
Yes, in regards to this case.
to my knowledge, in regards to this case, I'm the only one that's ever interviewed him.
Redirect.
Detective Antonor, is there a difference between a report and a narrative?
Yeah, so narratives go in reports. Reports are usually pretty long documents. They, in my opinion, usually have a lot of useless information, and then we get to the heart of things usually with narratives.
So way back, quite a while ago now, when Ms. Wells was questioning you about preparing a report, and you said perhaps a narrative, and she said, no, you're not listening, a report. Are those two different things?
They are, yes.
May I approach?
Okay.
Detective Antonor, what is that?
This is a felony report that gets turned into the prosecutor's office.
And what is this?
This is a narrative inside of a sheriff's office report.
So are those two different things in your mind?
They are two very different things.
Okay, so now, there's been a lot of questioning about you making up things and lying when you were interviewing the defendant. Is it illegal to lie to a person when you're interviewing them?
It is not. On the contrary, it's something we're trained to do during our interview and interrogation training.
Is it illegal to tell them that you have evidence that you don't really have?
Again, it is not. It's something we're trained to do during our interview and interrogation training.
So, for example, if you're interviewing someone about a rape case, would it be okay or legal for you to tell them that you have DNA from the victim that you don't really have?
It is not illegal. It is perfectly okay and something that is practiced routinely.
Why didn't you show Mr. Duffield the image?
Because that is a juvenile girl in a state of nudity, and I do not believe personally that it should be shared or shown to anyone, nor him, nor you, or anyone else for that matter.
Now, there's been a lot of questioning and back and forth, and is it child pornography, is it obscene, this, that, and the other. What words did you use to describe this image?
When I was talking with James,
Yes.
I believe I just said that it was a young girl or in a state of nudity or something similar to that.
Now, and what did the defendant admit to possessing?
Images of young girls is, I think, exactly how he worded it. I could be off by a word or two, but that's what he said, is young girls.
And I'm paraphrasing here, but did he admit that he possessed images of girls 16 and up?
I believe he said that he liked girls 16 and up, and that's what he downloaded onto his flash drive, I believe.
Thank you for correcting me. Did he say that, did you confront him with this, that with images of girls younger than 16?
What do you mean?
Did you confront him with looking at things of girls younger than 16?
Not with the images. I did confront him as far as the age 16, and I asked him if it would be fair to say that he was maybe a little embarrassed, but was attracted to girls younger than 16.
And what did he say?
He stated something substantially similar to, yes, a little bit younger.
Now, I'm just going to briefly cover this because I think it's been beat to death, but on page 14 of the transcript and in the interview, there was a portion where he asked when this happened,
Yes.
and your answer was,
I'll review it real quick, if that's okay. I told him back last summer,
okay, so, and when did you interview him?
April 25th.
So it would have been the summer of 22.
Correct.
Now, what did he tell you, when I say he, I mean the defendant, what did he tell you he was doing with these images after he put them on his flash drive?
He masturbates.
Now, from that, did you infer that these images were of nude women, nude girls?
I believe that was my assumption, and I believe it was a safe one.
Why didn't you do a search warrant of his electronic devices?
We had no reason to believe that he possessed any further child pornography. He told me during the interview that he saves his pornography onto a flash drive. That's where he views it, masturbates to it, and then deletes it.
Why didn't you send the computer to BCI?
Again, for the same reason. We had no reason to believe that there was any more child pornography on the computer.
Why didn't you focus on the brother and nephew?
Because James told me during the interview that he was attracted to juveniles and that he possessed images at one time of young girls, that he masturbates to these images, and that's what we had, was one of these images. There was no reason to believe other people were looking at them when James is telling me everything he's told me.
No further questions.
All right, thank you. You may step down. All right, ladies and gentlemen, we're going to adjourn for lunch, and we're going to take, it's 12:17, so I'd like to be back in the jury room by, say, 1:25, so we can get started at 1:30. During the break, remember the instructions of the court, you're not to talk to anyone about this, not to discuss the matter among yourselves, not to do any research online about it, you're not to make any posting about it in any way, shape, or form in any social media. Don't permit anyone to discuss it in your presence. Don't speak with any of the witnesses or the parties in the action. So, 1:25.
Please rise.
All right, we're back on record. State versus James Duffield. Remind everybody, keep your electronic device turned off. And we're still in the state's case. Your next witness.
Detective Sergeant Erica Engle.
Have you been sworn in? You have? All right. Just take a seat there and pull the microphone over in front of you, please. All right, you may inquire.
Please state your name for the record.
Sergeant Detective Erica Engle,
And can you spell your last name for us?
E-N-G-L-E.
Are you currently employed?
I am,
Where are you employed?
the Highland County Sheriff's Office.
How long have you been employed there at the sheriff's office?
Roughly 22 years.
And what are your job responsibilities there?
So a lot, actually, kind of anything that is required, anything in the office other than dispatch I've done. So anytime there's somebody that needs to fill in for any position, I can do that. My day-to-day operations is to investigate any kind of crime. I primarily investigate felonies more so than misdemeanors.
And were you employed as a detective in the summer of '22?
Yes,
Did you receive a report from ICAC?
I did.
What is ICAC?
I generically call them the internet police. It's the internet crimes against children.
And do you, just briefly, what do they do?
So anytime something, this is my understanding. I don't know an actual job description of ICAC, but my understanding of what they do is they are a hub for internet data that comes in.
Speculation.
Pardon me?
Speculation. Should
Well,
have
I'm
said-
going to overrule it. Yeah.
My understanding is they get information from different internet entities where if something's done wrong over the internet, they report it to local jurisdictions that it applies to.
Okay. And did you receive a report from ICAC?
I did.
And what was the nature of the report that you received from ICAC?
Child pornography.
Objection.
I'm sorry, I didn't hear. What did you say? Repeat the question.
What was the nature of the report that you received from ICAC?
Okay. I'm going to overrule it. It's not being offered for the truth of the matter asserted. So, you may answer.
Child pornography.
And why was it sent to you?
I don't really know how I became the local contact, but for whatever reason, anytime a case is forwarded to the Highland County Sheriff's Office, they have my email contact and they send it to me.
So, what is an IP address?
I would call it a thumbprint for your internet address.
I'm going to hand you what's previously been marked as State's Exhibit 1 for identification purposes. Do you recognize this?
I do.
And what is that?
This is the image that was sent to me in the ICAC report.
And is that a true and accurate copy of the image that was sent to you?
It appears so, yes.
I'm next going to hand you what's previously been marked as State's Exhibit 2 for identification purposes. Do you recognize
Objection.
this?
Wait a
I
minute.
guess if we could,
Pardon me?
You have it.
State Exhibit 2. All right, you have it. Okay, overruled.
What is that?
This would be the results of a search or subpoena that ICAC completed.
again,
Is that a
objection.
circle?
I'm sorry, what?
Objection, confrontation, hearsay.
All right, well, approach, please.
I did.
And what is that again? I may have asked you, if I did or not.
My understanding of this piece of paper would be the results from an ICAC subpoena they filed with Charter Communications.
Now, based on that, did you then, were you able to ascertain the address that was related to the Charter Communication IP address?
I was.
And what address is that?
11109 Sunset Lane,
Is that-
Hillsborough,
I'm sorry.
Hillsborough, Ohio.
Is that in Highland County?
It is.
And based on the report, what steps did you take?
So I did do a grand jury subpoena that was unfruitful as far as the email associated with the address. As far as my next step, we called him, Mr. Duffield, in and asked him to come in for an interview or speak to us.
Do you see the person known as Mr. Duffield in the courtroom today?
Yes.
And can you point him out to the court, please?
The fella in the blue shirt and dark blue tie.
No further questions.
Cross?
Go ahead. No, go ahead.
Afternoon, Detective.
Afternoon.
Hopefully, we'll be a little quicker than the last witness. Your office was contacted by somebody, I think, up in Cleveland. Does that sound right, initially?
So we received these tips through a ICAC data system, which is obviously over, like not email, but it's a program that you have to log into, and those cases are assigned to you. You don't normally ever talk to somebody on the phone or.
So this ICAC never reached out to you directly. They reported to someone else up in Cuyahoga County, Cleveland.
Cuyahoga County Prosecutor's Office, it's actually the one that assigns the cases in Ohio to what law enforcement entity that it needs to go to.
Okay. Now, and I apologize, I'm going to digress just a little bit. You've been with the Sheriff's Office for about 22 years, a little more. You went through some academy, IPATA certified.
Yes, sir.
Okay. You learned how to prepare narratives, written reports, right?
Yes,
You were taught the importance of being truthful in those statements.
I was.
At some point during your training, either initially at your academy training or maybe even in some subsequent training, you were taught some testimonial skills, how to testify from a witness chair.
It's been a long time, but yes.
Okay. Matter of fact, in 22 years, you've probably had a lot of experience sitting in a witness chair.
Actually, to be perfectly honest with you, no.
Really?
Yes,
You don't testify very often.
I don't. Until 2018, I didn't really hold a role with the Sheriff's Office that required testimony or that cases that went to a trial or a court.
Now, this isn't the first time you've testified, sworn testimony in the Duffield case, is it?
No,
You testified at grand jury.
I did.
Sworn testimony there.
Yes.
That was after your coworker had interviewed on video Mr. Duffield.
Yes.
During the interview process, or towards the end of it, your coworker came and spoke with you.
I'm sorry.
Towards the conclusion of the interview of Mr. Duffield. The other detective came and spoke with you before he concluded the interview process. Do you remember that?
No, not necessarily, no. I don't recall that.
Fair enough. At some point, you had a chance to review the video recording of the interview?
Yes.
You were able to look at that before you went to grand jury?
Yes.
And during your prior sworn testimony, you told the grand jury, that Duffield had admitted he's sexually attracted to underage
Your Honor, I'm
females?
gonna object. He has no idea what she testified to a grand jury.
I would certainly hope not, and I'll sustain that and admonish you not to talk about anything that happened in the grand jury. That's not the issue before this jury.
I'm going to show you a copy. May I approach
You may.
bill of particulars? You have an opportunity to review the bill of particulars signed in this case.
I've never seen a bill of particulars in this case, but I'll look over it.
Okay, would you take a look at it, please?
Your Honor, again, I'm gonna object. What's the relevance of what the bill of particulars says?
I don't know why she's allowed to argue
Wait a
it.
minute. He's asking a question, so he's the one that argues the points that are raising an objection. Okay, you don't get to tag team. All right. Now, I would agree. I don't see the relevance of that, and I'll sustain that. Prosecutor prepares a bill of information, not the witness.
I understand, Judge. It's actually not her.
Or the bill of particulars, I
I
should say.
I know what you mean.
Yeah.
And it's
Clear
not
it up
her,
in the record.
in all fairness, it's not her signature at the bottom, but
That's
just
correct.
trying to figure, this is a document that was provided to us in preparation for this case, and we certainly are
She would not be privy to that because she's not charged with discovery. The
And that's-
prosecutor is, so your inquiry is off line.
precisely why I asked her if she'd seen it.
Okay, don't argue with me. Move on.
I'm not-
Ask a different question. Can't ask questions about that document.
May I approach?
Witness,
Yes.
you may.
I'm going to show you a document that appears to say chain of custody, summary of defendant, statement to law enforcement. Do you recognize that document?
I do,
And was this was something that was prepared by you?
yes,
Yes?
yes.
In the lower portion, you see where it says he stated that he was sexually attracted?
I do.
What's the full statement that you put in that?
James admitted that he is sexually attracted to underage females, preferably between the ages of 12 and 16.
That statement was never made on the video, was it?
So when
Yes or
I...
no?
Answer.
That
Good question.
statement
Answer the question.
That statement was never made on the video, was it?
So when I wrote this, I paraphrased the entire interview. Obviously, there's 5 lines in this statement of facts as far as his summary. Obviously, 5 lines doesn't cover a 30-minute interview. So in one of his statements in the interview, which I believe Sergeant Antonor testified to, he would say something similar to a little bit younger than 16. I don't know how to pick an age, so I picked an age. Obviously, he said it wasn't young children, so I picked an age younger than 16. That would also be a teen, because earlier in his interview, which I obviously viewed,
I'm going to stop you right there.
Okay.
He never admitted that he was sexually attracted to 12 to 16-year-olds, did he?
the interview that I watched, he implied that he ejaculated to images
That he
or
downloaded.
videos or pornography of that of a young teen.
18 and 19 is a teen, isn't it?
I would agree with that.
He never said he ejaculated to a 12 to 16-year-old, did he?
Well, I can't testify to what he said in the interview because Sergeant Antonor's already been questioned on the interview, what he said. But when I wrote this statement, a portion of the interview that I documented for purposes of this statement alone, when Sergeant Antonor asked him the question, would you say 12 to 15 or 12 to 15? I'm not quite sure how that goes without listening to the
Are
interview.
you making up Sergeant Antonor's testimony like you're making up his? Because you told the folks, the jury, that you made up the age, 12 to 16. Is that what I heard?
That is.
So you made up the information that's in your narrative statement. Is that
He never
your
gave
testimony today?
My testimony is he never gave a specific age. He just said slightly younger than 16.
So you made up a self-serving age range, right?
Objection as to self-serving.
Well, I'm going to overrule that.
You made up an age range that fit your indictment or your testimony. You made up the age range that fits your testimony at grand jury to get the indictment, right?
Objection, again, about grand jury testimony.
Again, don't refer to the grand jury again. I'm not going to warn you again. You can't ask questions about what happened in grand jury. You don't know. And she's not permitted under the law to testify to that without prior court approval, which has not been requested. So it is sustained. Do not mention it again.
May we approach?
No.
You made up the statement in your narrative about the age range, yes or no?
I paraphrased the.
Yes or no?
It's not, I mean, you can yell at me, sir.
I'm not, apparently you didn't hear my question because you're answering something different. Yes or no? You made up the age range 12 to 16.
I paraphrased an interview, sir.
You got the first notification on this on August 22.
Yep.
You let it sit for 10 plus months, right?
Yes, I would assume that would be correct if we did not do anything with it till then.
Child pornography is kind of a serious crime, isn't it?
I would agree with you.
And you let it sit for 10 months without doing anything?
That would appear that way, yes.
You talked about a question about internet or IP, what an IP address is. IP stands for Internet Protocol. Does that sound right?
I'm not sure what it stands for. I'm just generically
Just telling
familiar
the jury
with
what it means. Don't know what it stands for, but you're telling them what it means.
I'm generically familiar with it, yes.
It stands for an address, not a computer, right? It's not a particular device. If I get on the courthouse internet, on my cell phone, anything I download is going to have that IP address, right? It's not connected to my phone, it's connected to the address, the IP address.
Are you asking me a question?
Yes.
What is your question? I'm sorry.
My question is that the IP address is related to a location, not a device.
To be perfectly honest with you, I've never educated myself completely on exactly what an IP address goes to. I'm familiar with it on my own personal experiences, which I'm not allowed to testify to.
And there aren't any experts here today to testify to the ladies and gentlemen of the jury and explain precisely how this whole IP thing works, right? It's just you and your fellow detective.
It would appear so.
The testimony that we've heard today has all been a summary, as you all remember it, as to James's statements back in April of this year, right? No one's going to play from your team. No one's going to play the video, the interview. It's just your summary.
Are you making statements or are you
I'm
asking me a
asking.
question?
I'll put "is it" at the end of it. How's that? No one, the testimony that we've heard today about James's statement is just yours and the other detectives' summary of what you recall hearing, isn't it?
I don't believe so, no.
We didn't hear his actual words, right? We didn't hear the recording.
I hear the recording.
Right. And we have just I appreciate your candor telling us you made up the age range.
I don't make a habit of lying on the stand, sir.
Only in your narratives.
Objection.
I'm going to sustain that. Move on.
How many times did you watch the video?
Once.
You remember hearing James say, "I can't tell what's photoshopped"?
Not without hearing it again recently. It's been back several months ago when I even watched the interview, so I haven't watched it recently.
No reason to doubt he said that, though, right?
It was not something that Sergeant Detective Antonor and I ever discussed.
Whoever's in that, or whatever that image on Exhibit 1 is, you don't know a name,
No,
you don't know a date of birth,
I do not.
don't know an address, state,
I do not.
county, country.
I do not.
Somewhere I saw some description that said in a tropical setting. Was that part accurate, at least accurate?
Well, if you, which I'm sure you've looked, it would appear somewhat tropical-ish, would be my description of the background of the photo.
You've not personally observed any metadata or any other computer science stuff that would show that it's an actual photograph and not a AI or photoshopped image, have you?
Due to training budget and small staff, we haven't been trained, we haven't been sent to training on something like that.
And I understand, this is a smaller county. Don't have the budgets of maybe Cuyahoga County or Franklin County, but you didn't farm it out to anyone else to ask them to look at it. No.
I couldn't speak to the conversation that I've had with Cuyahoga County or ICAC. I'm not allowed to give testimony of their opinion.
You've personally, you're the witness here right now. You've personally not seen any data to show that this is an actual real human being. Looks real.
Just that of a pediatrician. Other than that, no.
Did you hear her testimony earlier that she doesn't know whether it's a real human? You were in the room.
I did hear her testimony, yes.
And I apologize, I'm not trying to beat a dead horse, but I'm going to. No search warrants in this case, right?
He downloaded on a flash drive that he said he deleted, so there
Oh.
was no need to look for one.
So are you telling me that if someone deletes an image off a computer device, it's irretrievable forever?
No, that's
Okay.
not what I'm telling you at all.
You didn't try and get any search warrants?
Nope.
When someone, actually you called him and said, I want to interview you, even though you handed him off, right?
What's that?
You
Sorry.
called James and said, I would like to talk to you about an investigation.
Yes,
Do you remember that? He voluntarily came in and freely spoke to your coworker.
yes.
No one asked him to bring any devices before or after the interview.
That is correct.
After the interview, no one tried to get a search warrant.
No.
Just about that. In order for this case to be indicted, there was a different burden of proof, which was just probable cause.
Objection.
Okay, I have warned you about that. I said no more questions about the grand jury.
I didn't say
Now,
grand jury.
yeah, you did. You said if we're to be indicted, and we all know what that means. Now, don't go there again, or you're going to face a sanction.
You understand that today, when we started, there's a presumption that he's not guilty, right?
Ask that again. I don't know.
Presumption that these ladies and gentlemen have to say not guilty.
Yes, they have an obligation to look at the evidence presented and make a determination based on evidence and find him innocent unless the state proves that he isn't.
I think I know what your opinion is, but you understand that they may come to a different conclusion.
I'm going to object and ask what the relevance of this is.
Yes, I'm going to sustain that. That's not her job to decide.
Yes.
Go back to the interview for a moment. There's never an admission that that or any other specific image was downloaded.
Objection, Your Honor. At this point, I'm sorry, I can't
No.
see you.
I'm going to overrule the objection. Go ahead. Ask the question again, please.
Thank you, Judge. James never admitted to downloading that specific image or, for that matter, any other specific image.
James was never shown this image to admit to.
On this 26 whatever minute video, he never stated that he masturbates to child pornography, did he?
I can't testify to that interview without looking at it again.
You don't specifically recall it right now, at least without not looking at it again.
That would be correct.
There is no evidence that James downloaded any image on or about June 2nd, 2022, is there? Go ahead.
I'm not sure how to answer that because I'm not sure what your question is.
I'll move on. The question was clear. During the interview, James specifically told your coworker that his brother lived with him at that specific time period, didn't he?
I believe that's what Sergeant Anstor, not necessarily that specific time, but back over the summer. That could be May, that could be August, that could be June, it could be July.
Thank you.
Redirect.
He didn't ask after he brought this up, but why did you do nothing with the case after you first got it?
So Sergeant Antonor and I are the only two detectives in the county. The child was unidentified. There was one image. There wasn't multiple images. So in order for us to be efficient for the county and everybody in it, we have to prioritize cases based on urgency and what we can and can't prove right now. We often do case review to see where, if there's any case that got slipped through the cracks. This happened to be one of them. Just because it slipped through the cracks did not make it okay, so we needed to do something with it, and we did.
Now, you just testified that you and Sergeant Antonor are the two detectives for the county. What types of cases would have priority over this case that you guys would have handled in that time period? Definitely not.
Yeah, I think it is. I'm going to sustain that.
Thank you, Judge.
Were you handling other cases during that time period?
Yes.
Objection, beyond the scope.
Sustain.
Your Honor, defense counsel has their mic turned off.
Oh,
I apologize for
yeah.
speaking.
Thank you.
What physical address did the IP address attached to the image come back to?
11109 Sunset Lane, Hillsborough, Ohio.
Who lives at that address?
James Duffield.
Is it required that you know the name of the child depicted in the picture for it to be obscene?
Objection beyond the scope.
Absolutely.
I'm going to sustain that.
Your Honor, may we approach?
All right. You may re-ask the question.
Is it required that you know the name of the child in the image for you to be concerned with it?
No, no.
Is it required that you know the address of the child in the image for you to be concerned with the image?
We would love to have it, but absolutely not.
Why did you do no search warrant?
Objection.
Overruled.
Because during the interview, Mr. Duffield made mention that he downloads things or puts things on flash drives and deletes them. We're required to, when we do a search warrant, to provide evidence that we would find something at a search warrant should we want one. And if he's already told us that he's deleted them, I don't know what we could gain from that. He has no reason to lie to us.
Mr. Meadows essentially said that you made up the portion of your statement when you said 12 to 16. What happened in the interview that led you to put that statement in your report?
So in one portion of the interview, Sergeant Antonor spoke about, would it be fair to say that it would be less than 16? And he said maybe a little.
When you say he said, maybe a little.
Mr. Duffield
Okay.
said maybe a little. I can't determine what a little is, but I did know in a different portion of the interview, it definitely wasn't little children. When I say little, babies, toddlers. So I paraphrased what I believe to be a little younger.
So, and that's where you came up with 12 to 16.
Yes.
Did you, do you remember in the interview if James admitted that he downloaded images of young females?
Yes.
Do you remember it, or he did say that?
Repeat your question?
Do you remember if in the interview, do you remember in the interview, did he say that he downloaded images of young females?
I believe so, yes.
And what did James say he did with those images after he downloaded them?
He watched them, he ejaculated to them, or masturbated, I'm not sure the exact term he used, and then he deleted those images.
Objection.
I'm going to sustain that.
Move to strike and instruct.
It's stricken. It's already stricken.
No further questions.
All right, you may step down.
Judge, if we could approach.
Yes. Yes. You say you would like to approach? Okay.
Yeah, if we could please
All right.
approach.
Where's he? Just put him there. All right. The jury, I'm going to ask you to retire to the jury room. We're going to have some legal discussions here we need to discuss outside your presence.
Oh, I'm sorry, yeah, thank you.
Okay. All right, now we're back on the record. The state rest,
Yes.
Okay.
We would move to admit exhibits 1 and 2.
all right? Any objection?
We object to exhibit number 2. I don't believe, based on her own testimony alone, that she is qualified to testify to page 2 of this document regarding the subscriber record. She does not know how this document is generated. She couldn't testify to anything really regarding any of this.
Well, Miss Engle, Detective Engle's not the person that's certifying the records, and the records, I agree with you, they do speak for themselves. Any characterization she would make of them would not be appropriate. I did sustain some objections, but to the extent there were objections or were not objections, whatever testimony she offered is in. So the court will overrule the objection and admit that.
If I could further make the objection that it violates Crawford, we have the inability to cross-examine the individual who conducted
I think
this.
Mr. Meadows did raise a confrontation
Right.
issue, and I ruled under the business records 2317, 40, 41, I think maybe 42, and the evidence rules provide that business records kept in ordinary course of business can be admitted as an exception to the hearsay rule, and that's been upheld by the Supreme Court of Ohio. So court will overrule that objection as well.
And finally,
Those
foundation.
are admitted.
My last objection to that same exhibit would be lack of foundation.
Same ruling. All right. Okay, state rest,
Yes, Your Honor.
all right. Which one are you going to
I'll
speak?
So we would argue that we're requesting an oral motion for Rule 29 under the rules. The lack of evidence in this case to establish that, one, this is a real live child. No one has testified that this is a real live child, which is required under the statute. This could be an AI image. We do not know. There is no evidence tying, there's no confession that my client stated that he had anything to do with this picture, that he saw this picture on June 2nd, that he possessed this picture, that he downloaded this picture, that he did anything with this picture. A lot of testimony has been presented regarding his attraction to young girls, and there's been a discrepancy about their age, but that's all what I consider to be 404B evidence, to be frank. When it comes to this picture on this one count indictment, no one has put this in the hands of Mr. Duffield. Essentially, we have, according to a business record, that an IP address is associated with James Duffield. And then if you look at that IP address, there are multiple individuals who have email addresses, including Crispell shared, using that same IP address. So there is multiple questions as to the veracity of the statements that were made by Detective Antinor regarding statements made by Mr. Duffield. And even if you take everything that Detective Antinor said is true, a confession alone does not, which this is not, but a confession alone does not sustain a conviction. It's not enough. There simply is not enough proof to submit this case to a jury. And I understand there are reasons, there are limitations, but regardless, there are witnesses that could have been called. There were witnesses listed by the state. The state chose not to present evidence for. The state chose not to pursue. Based on that, there is not enough evidence to submit this to a jury.
Thank you. Ms. Collins?
Thank you, Your Honor. I would disagree and say at this point we are to the point where reasonable minds could come to differing conclusions, and based on that, that is a decision for the jury. I am looking through the jury instructions, and I don't see anywhere in here that says the state has to prove that it's a real little girl.
The what? The state has to prove what?
That it's a real little girl. I'm looking through the jury instructions. I don't know.
Well, minor is defined as a person.
Right, but our witness, our expert witness from the pediatric doctor said that it appeared to be to her, and a minor. She pointed out the things that made her believe that it was a minor. And I think at this point, you could draw the inference that it is both a minor and a person. There's no evidence otherwise. I mean, everyone believed that it was. There's no evidence that it's, definitely no evidence that it's not. And yes, I recognize it's the state's burden of proof. But based on that, coupled with his confession, I agree that a confession alone wouldn't be enough, but we have more than a confession here. Based on that, as well as the purpose of him downloading the videos or the pictures, I think is enough to present it to the jury. Thank you.
Judge, if I may, in rebuttal, you're correct that it says a person, right? And so she says the evidence and proof that we can submit this to a jury is that the pediatric doctor testified that this was a person. That's not actually true. What she testified to is that she couldn't tell the difference between if this was an AI image or if this was an actual person. The purpose of the doctor's testimony was to say that this child was of a pre-pubescent or pubescent age, or that this was a younger child. But again, no one has testified from that stand that this is an actual child. And in typical cases like this in ICAC and NCMEC, there are a plethora of search engines that law enforcement can use to run this particular picture through to see if this child has been identified.
Identified, but not as whether or not it's a child. That's misleading.
If I could
Okay.
finish.
You made your point, she's making hers. Go ahead.
Right. And the reason is because it has to be an actual live human being. So when we say they've been identified, they know who that person has been legally identified as a human being. And in this case, there is no evidence of that because law enforcement didn't use any of those resources to determine whether or not this child has been identified in NCMEC, has been identified by ICAC, has been identified by the CHIP, all the acronyms that exist. So there is no evidence that this is a real person as opposed to an AI image. And based on that, there's not enough evidence to submit this to a jury.
All right, well, with regard to that issue, there's no evidence that it is a product of AI. You made a lot of suggestions, but the questions that you ask are not evidence. They're just questions. And so, clearly the jury could conclude that this is a real person. Whether the sheriff could have done other things, clearly, that's a question that is legitimate. So the court finds that for purposes of the proof that this is a real person, that there's sufficient evidence, or it's a minor under the definition, which is raising a legal issue because it's interesting that in terms of AI, whether that's going to need to change definitions in the statutes in cybercrime. But in any event, the court finds that there's no evidence to the contrary, and speculation is merely speculation. It's not evidence. So the court does find that, in terms of this being a minor depicted in non-obscene material, that the evidence clearly shows that. Now, the evidence also shows that the defendant has made admissions of knowingly downloading things off the internet that show younger women engaged in sexual acts, which would be obscene material as well. Now, I'm looking at Exhibits 1 and 2, and Exhibit 1 is the photograph. And Exhibit 2 certifies who the subscriber of the IP address is that was issued. I don't see anything that connects Exhibit 1 and 2. There's nothing in the record that indicates that Exhibit 1 was downloaded to the IP address in Exhibit 2. We know that that's the defendant's address, but we don't have any information in the record that I can see that shows that this was the image that was downloaded. The defendant admitted to downloading images, but not this one. He was not asked this. Now, yes, he admitted to it, but I would make it akin to somebody had been committing a series of bank robberies and asked it, and you're investigating a local bank robbery, and you ask if you've been committing robberies during this period of time, and they say yes, but don't ask them about this particular one. That's not an admission. He was never shown this picture. There's no evidence. And furthermore, the other thing that bothers the court is there's no evidence of any particular device to which this was downloaded. And this is the first time I've seen a one picture, one count indictment on this type of case. Most of the time there's many, many pictures. There's more, and I do know that from past testimony, photographs can be, information can be retrieved from computers. Now, if it's downloaded in flash drive, it has to be downloaded through a device. Flash drives, I don't think, have their own internet capability, at least none that I've ever been familiar with. And so they would have to be downloaded through a device, and we don't have any evidence before the court on that. And so the problem I think we have here, or the state has here, I should say, is that I don't find any evidence that this particular photograph is the one that's referred to in Exhibit 2. There's no identifying information on Exhibit 1 other than photographs to print out, and there's nothing on Exhibit 2 that references Exhibit 1. And so, based upon that, the court finds that the evidence is insufficient to sustain a jury finding the defendant guilty, and accordingly, the court is granting the Rule 29 motion and ordering the defendant discharged. All right, Mr. Strain, if you would bring the jury in, please.
Thank you, Your Honor.
Thank you, Your Honor.
Don't thank me, I'm just doing my job. I don't like attorneys to thank me for doing my job. Don't do that again.
I wish I had one.
Get me seated, folks. Get me seated, please. We're on record.
Yes, Your Honor.
All right, ladies and gentlemen, during the break, the court made a legal ruling at the conclusion of the state's case. The ruling of the court is that the evidence is insufficient to permit a jury to return a verdict of guilty. The court found there was no connection between the picture and the records for the IP address. It shows that this was a picture that was downloaded, and there was no other information to show it was downloaded to any particular device that was owned by, used by, controlled by, possessed by this defendant. And so I made the decision as a matter of law to dismiss the charge. It's strictly a legal question. It's not an evaluation of credibility, and this just simply means that I've determined that under the law, if a jury were to convict, it would not be supported by the law. Now, you may ask me, well, why did we have to sit through all this? Why didn't this come up and you do this sooner? Well, I'm like you. I never heard any of this evidence till today. A lot of people think the judge knows everything that's going on. I wish that were, well, I don't wish that were true, because if I did, it'd be improper. The judge is not supposed to know what's going on. I don't know what's going on in the evidence in the case till the case starts. I hear it at the same time you do. Now, if there's a ruling, if there's a legal issue, I may see something, little pieces here and there. But, I've never heard any of this evidence before today. This is something that I can't do until I hear it and it's all before the court. This is kind of an unusual thing. This is my 111th jury trial, and this will be the third Rule 29. It's called a motion to acquit after the evidence is presented by the state that I've granted. It's not something I do lightly, but, I'm paid to make not enough, but I'm paid to make the tough decisions and apply the law regardless of what I think. And so that's what I've done. So the defendant, the charge against the defendant is dismissed. He is discharged, and your service is complete. your service was necessary for the reason I just explained. But we do appreciate your being in here. You will not have to serve again the rest of this term. If by chance our computer should screw up and pull you out, it really wouldn't be the computer, it'd be my bailiff not putting your name in. And you get called again before the end of this year, just call in and say, hey, I was on that case November the 6th, and judge said I didn't have to serve again, and you'll be excused. You will be eligible to be drawn again, not next year, but in 2025, for those of you who would like to have further experience. So, just so you know. Again, thank you for your service. You're excused. You can go ahead and go downstairs to the clerk's office, claim your voucher, and any work that you may need. Thank you again for your service.
We didn't make you provide that to us. We typically don't give it. That's what I'm saying. We didn't make you provide that to us. I know the picture. We don't typically like flash drives. We have to give us the flash drive. Sure, why did you give us the flash drive?
This is the flash drive, what you gave a shot of. I'm getting it back. I know, you can totally understand. Did you want me to give you $10 for a flash drive? No.
We just don't want to go along.
Well, that would be fine, but do you want me to go look at it and then you take the flash drive back?
No.
Because we typically do not provide flash drives to the attorneys, that's what I'm saying.
I understand. And
Okay.
most of the courts, like before,
Can cover the
we
cost.
used to take a stack, a spindle full of CDs to highway
used to do
patrol.
that too.
So if it didn't,
Flash
now I've
drives?
just got a bag of flash drives.
Yes, that's why I
You can
asked if you want that back. because
Stomp
I
on it,
can't-
pinch it, burn it, whatever you want to
We'll
do.
reuse it,
I'd
but if you want it
reuse
back, I will
We
need
just-
it right
we don't-
now, give
We
it
don't
back
want
today.
that at our office for any purpose.